about the partner, by holding out. So, we can see what it is. A partner by holding out is a person who, though he is not a partner in a firm, but knowingly allow himself or herself to be represented as a partner in a firm, in which it says that the person can be a partner in an organization without holding very much active partnership. That means a partner by holding out is a person who, though is not a partner in a firm, but knowingly allows himself herself to be represented. He can represent or he can be a partner, he can act as a partner, but he is not the partner. In such a person becomes liable to outside creditors for repayment of any debts which have been extended to the firm on the basis of such representation. In case the firm get debts or other liabilities, then this person is also liable to repay the debt. So, here again I will say you, a partner by holding out is a person who is, though he is not a partner, but he accepts or he acts as a partner of the, or he represents as a partner in a firm. Such a person is also liable to outside creditors for repayment. He is also liable to repay the debts of the same organization. In case he is not really a partner and wants to save himself from such a liability, in case if he is not ready to repay, he does not want to repay such a debts, then what he needed to do, he should immediately issue a denial. In that denial, he has to clarify his position that he is not a partner in the firm. He has to make it clear or clarify his position. If he does not do so, he will be responsible to the third party for any such debts. So, dear students, what did you understand from this paragraph? From this paragraph, you understood that there are partners in a business, and sometimes a person can also represent as a partner in that organization. He can act as a partner, that is known as represented as a partner in a firm. A person can be. Such a person becomes liable to pay outside the repayment of the debts, etc. He also needed to repay. In case he doesn't want to repay such a debts, then he has to clarify it before. That is what actually this paragraph says. So, partners, of course, in a business organization, all partners are liable to repay the debts. In case the organization creates any debts, then all partners are liable or responsible to repay the debts. So, here actually it says that actually a partner, in case a partner, so such type of partner, who is that? A partner by holding out a person who, though is not a partner in a firm, but knowingly allows himself herself to be represented as a partner. A person is represented as a partner. That partner doesn't want to repay the debts, then he has to clarify it before. That's all. Then we can move on to the next point. Types of partnership. What are the different types of partnership? Here it says partnerships can be classified on the basis of two factors. What are the two factors? Duration and liability is important. So, the duration and liability. Duration means that is, of course, that is connected with the time period. The liability means the responsibility, liability, etc. Then on the basis of duration, we can check what are the specialities in that. There can be two types of partnership. Partnerships at will, that is important point, you need to note this. Partnership at will and particular partnership. So, two types of partnership are there. One is partnership at will and another one is particular partnership on the basis of liability. All these are happening on the basis of liability. The two types of partnership include one with limited liability, one is having very limited liability, and the other one with unlimited liability. Yes, of course, in the business, of course, there are liability. So, the liabilities must be repaid by the partners alone. So here it says two types of liabilities in partnership. One is with limited liability and another one is with unlimited liability. These types are described in the following sections. We can see what are the different types of liabilities and its significance. The third point, the point is that here we are going to, in the third paragraph, we are going to see what are the classification on the basis of duration. Partnership at will. So we are going to know more about the partnership at will. This type of partnership exists at the will of the partners. It can continue as long as the partners want and is terminated when any partner gives a notice of withdrawal from partnership to the firm. So this point you need to remember. Partnership at will. What are the specialities and special features of the partnership at will? This type of partnership exists at the will of the partners. It can continue as long as the partners want and is terminated. Can be terminated. Can be removed from the partnership when any partner gives a notice of withdrawal from the partnership to the firm. So they can be partner, and sometimes if they want they can get out of the partnership also. The partner can give a notice of withdrawal from partnership. He has to submit the notice to the firm. That's all. So here we can see what is particular partnership. Particular partnership formed for the accomplishment of a particular project. That is for a special project they are making such type of partnership. Say construction of a building or an activity to be carried on for a specified time. That is for a particular partnership, for particular period or for particular mission they are making such type of partnership. So specified time period is called particular partnership. This type of particular partnership is for attaining some special accomplishment. They come together and make the partnership. The project is a construction, then sometimes what is a specified time period for making a particular project, they come together and make this type of partnership. That's all. Then it dissolves automatically when it can be disclosed the closure, or it can dissolve any time when the purpose for which it was formed is fulfilled or when the time duration expires. So this particular partnership is actually can be dissolved only when the mission is over. Partnership, this type of partnership is forming only for accomplishing with a particular project. When two people wants to accomplish or wanted to do a special project, then this type of partnership can form. That is known as particular partnership. So we can see the next paragraph here, the classification on the basis of liability. What are the liabilities? Of course, in the business there are liabilities. The liabilities must be repaid by all partners, that we have already understood. Here the general partnership we are talking about. What is general partnership? In general partnership, the liability of partners is unlimited and joint. In general partnership, the liability of partners is unlimited and jointly they have to fulfill their liabilities. That's all. So jointly they have to fulfill the liability, they have to take care of the business totally together. Also, in case the firm faces some debts, then they have to work together and repay the liabilities. That's all. The partners enjoy the right to participate in the management of the firm, and their acts are binding on each other as well as on the firm. They all work together for the betterment and for the business benefits together, and the profits they share each other with a mutual understanding. They are taking any managemental decisions. Also when the debts occur, they have to repay all those debts together. That's what. Registration of the firm is optional. In such type of partnership, general partnership, registration is an optional. There is option. If you want, you can register, otherwise no need to register. The existence of the firm is affected by the death, lunacy, then insolvency or retirement of the partners. The existence of the firm is affected. Sometimes in this type of partnerships, existence is connected with death. In case one person die, or lunacy means that actually lunatic persons are there. Some mental problems or insolvency, the pauper or more debt, then they don't have money to repay, or a retirement of the partners, or everything can affect the organizations or this type of the partnership organization's future. So that you need to understand. Then we can move on to the another point, that is limited partnership. In limited partnership, the liability of at least one partner is unlimited, whereas the rest of may have limited liability. In this type of limited partnership, what is happening? Only one person is coming forward to take the liability, and he is the head of the organization, and all other people, they have limited liability. Such a partnership does not get terminated with the death, lunacy or insolvency of the limited partners. The limited partners, one person is the active member and the active partner, and he is the controller, he is the manager, and he is managing, promoting the business. But all other partners, they have a limited liability. So this type of limited liability some partners are having. In case such partners death or insolvency may not affect the organization's future. The limited partners do not enjoy the right of the management, and their acts do not bind the firm or the other partners. Limited partners might be more, so their death, their insolvency or their other problems may not affect the organization's future. So that is what actually we want. Registration of such partnership is compulsory. Such type of partnership, limited partnership setup of the business organization must be registered. There must be registration in such type of, then only register such type of organization, then only they have to work together. Where in this type of limited partnership, that this registration is must. Then we can move on to the next point. The sixth one is, the paragraph is, this form of partnership was not permitted in India earlier. Earlier this type of partnership was not permitted. The permission to form partnership firms with limited liability has been granted after introduction of new small enterprise policy in 1991. After 1991 only, this type of limited partnership is available in India, or such type of registration is possible in India. The idea behind such a move has been to enable the partnership firms to attract equity capital from friends and relatives of small scale entrepreneurs who were earlier reluctant to help. So after starting this type of limited partnership organizations, what is happening? This type of business organization can attract a lot of capital from friends and relatives. That is why the government introduced this type of limited partnership registration in India, so that actually more people are coming together and they are starting this type of setups in India. So due to the existence of unlimited liability clause in the partnership form of business, so what is happening? This type of business organizations are providing better opportunity for creating more companies in India. So more people come together and they start limited partnership business. The next point is partnership deed. What is partnership deed? We can see what is partnership. A partnership is a voluntary association of people. Some people come together they have friendly attitude, they have taken a decision with mutual understanding, they are coming together. A partnership is a voluntary association of people who come together for achieving common objectives. All members have some objective goals, they wanted to attain their goals, they wanted to fulfill their goals. That is why they are doing partnership business. In order to enter into partnership, a clear agreement with respect to the terms, conditions and all aspects concerning the partners is essential, so that there is no misunderstanding later among the partners. Before making the partnership, the people must have mutual understanding, they must know the terms and conditions and every aspects of the partnership business, so that there won't be any misunderstanding among them. So the mutual understanding and the purpose of their mission must be cleared very well before starting this type of partnership business. Such an agreement can be oral, by words or written. Written agreement is better. So because that is an evidence, that is a proof. Even though it is not essential to have a written agreement, written agreement is not a mandatory one or not a necessary one or not a compulsory one, but they can create a written agreement, no problem. It is advisable to have a written agreement as it constitutes an evidence of the conditions agreed upon. Written agreement is always with them, so that there won't be any misunderstanding among them in the future. So that written agreement is advisable here. The written agreement which specifies the terms and conditions that govern the partnership is called the partnership deed. What is the partnership deed? There is a written agreement, more people come together and they form a partnership deed, a partnership business. They must have mutual understanding, so that they know what they are really doing. There won't be any misunderstanding among them. So the written agreement which specifies the terms and conditions, in the written agreement there is a terms and conditions that govern the partnership is called partnership deed. So there is a partnership deed means there is a written agreement and understanding, and there are terms and conditions. So according to that terms and conditions, all these people work together. That is what the main point you need to remember here. The partnership deed generally includes the following aspects. What are the speciality, what are the aspects, what are the significance and features of the partnership deed? First of all, name of firm, there must be a name. Nature of business and location of business, what kind of business they are going to do, that they must understand before starting an organization. The nature of business and the location must be where they wanted to start. Duration of business, how long they are going to do. Investment made by each partner. There might be more partners in such type of business. So each partner's investment, how much money, capital invested in that business, that they have to mention. Distribution of profits and losses, each partner's distribution of profits and losses. In case the profits come, how much to be shared to a partner, and in case the losses are there, then how much would be contributed, that should be mentioned. Duties and obligations of the partners, what are the duties and obligations? The commitment, their duties, their rights, duties and everything must be mentioned in it. Then salary and withdrawals of the partners, each partner's salary must be mentioned, and how much can be withdrawn, a person can withdraw from the organization, that also they need to be mentioned in the contract or in the deed. Terms governing admission, retirement and expulsion of a partner, a partner's role, his power, his retirement and expulsion, how long he can be in the organization, and after that when he can get the retirement, everything must be cleared in that deed. Interest on capital and interest on drawings, capital interest and interest on drawings. So, in case they also take the organization take the money from outside, then how much interest would be paid, etc. must be, the interest on capital and everything must be mentioned very clearly. Procedure for dissolution of the firm, when if they wanted to do the closure of the firm, or where they wanted to stop the business or the partnership business, that must be cleared very well. The procedure, what are the procedure and what are the formalities, all those must be mentioned in that. Preparation of accounts and their auditing. Of course, a business organization want account, their own account, then they also want their auditing. Auditing must be cleared by a proper chartered account. The auditing means auditing, you know that actually how much profit, how much spendings and expenditure, everything must be cleared in that auditing. Then method of solving dispute, in case some disputes come, then how to solve all those dispute, all those formalities, all those points must be cleared in making the deed. So, when they make a deed, all these points must be cleared. All these are the main points we wanted to understand just before making the deed of a partnership business. So, here dear students, we were studying more about the partnership business, various kinds of partnership business we understood. We also understood some the merits and demerits, the advantage and the limitations of this partnership business. I trust you understood the point well, and you will go through the details more or read more and understand it. That is why. That is what here today's class is. So, I think I trust you understood the point well.